In this video, I'm going to be talking to you about what happens with your bail if your case gets dismissed or if you get a not guilty verdict. My name is Veronica. I am a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to represent yourself and win at your restraining order hearing. I do have domestic violence clients who, if it's their first time, I am able to get their charges dropped before court. The key really is to do everything you possibly can to get it dropped. But then they get slammed with a domestic violence restraining order, and already they have paid their bail, they have paid me, and so now they're faced with a third legal issue that can be very expensive. But the thing is, you can represent yourself at your restraining order hearing and win. You just have to know what to do. So I give you all the secrets there from A to Z and give you kind of a roadmap of how to win your restraining order hearing without spending even more money on an attorney. Okay, so let's jump right in. Let's talk about your bail and your bail bondsman and what happens if your case is dismissed or you win at a jury trial. So the short answer, and I know one of the many reasons people don't like lawyers, it's because this is often our answer, is it depends. So the bail bondsman did their job by posting bail, which allowed you to leave jail. And how it works is, let's say that your bail was $50,000. That is frequently the bail for a PC 273.5A, which is the felony domestic violence, corporal injury to a spouse or a cohabitant. Typically, when your bail is that large amount, those tens of thousands of dollars, that is the amount that the bail bondsman actually has to post with the court, like in real money, has to post with the court in order for you to get out of jail. And you pay them 8 to 10%. And by the way, typically, if you have a private criminal defense attorney, they will give you a lower rate. So typically they will give you more in like that 8% range. And even if you don't have the attorney hired right then, I mean, you're in jail, you just got arrested, typically they will let you submit information about the attorney to them, or have the attorney submit information and then give you that discount retroactively. So the bail bondsman did their job by posting bail, and that allowed you to leave jail, but each bail contract is different. So it's important to check the contract's details to see if it talks about refunds, because maybe it will. Sometimes the bail contract does state that you can get your bail bonds fees back if the case is dropped before court. This is what I aim to do with a lot of my clients. A lot of my clients, this is their first time ever being arrested for domestic violence. Many times they didn't actually do anything wrong. And it's a matter of explaining who they are as a person, submitting mitigation on their behalf. Those are good things about them, hardships that they've experienced, character letters. Sometimes I send them to therapy, to domestic violence classes, all of which are not an admission of guilt. They are instead something to basically reassure the DA that they are never going to see you back in this position. This was a once in a lifetime thing for you. You're not an abuser. You did not commit any offense here, and they're never going to see you there again. But sometimes bail bonds companies will not give refunds, especially if they have already paid to get you out of jail. I mean, they have done their job. So it's important to understand that a bail contract is both a promise to pay the bail bond company fee, usually 8 to 10%, and an agreement that the company will cover the full bail amount if you, as a defendant, don't show up in court. And that is what happens if you abscond, if you do not show up for court and the case has not been dropped. They will send, like, that's when you see dog bounty hunter, right? Sometimes people hope that the police will have to pay back the bail bondsman as kind of a penalty for arresting someone who didn't do anything wrong and then the case getting dropped before court. But unfortunately, that does not happen. There is no law that requires the police or the DA's office to pay back the bail bondsman. I wish that there was. Maybe they would be a bit more careful with who they arrest, but that is not the case. Also, if a case is dropped due to not enough evidence or due to a character packet submitted by your attorney, it is important to remember that the DA can still charge you later if new evidence comes up or if you get arrested again before the time limit to charge you, the statute of limitations, runs out. So if you're told that your case has been dismissed before court and decide to stop paying the bail company, that could be a big mistake, because first, if you don't finish paying your fees, then the company could take you to court for the money you owe. Bail bonds companies are pretty aggressive with that. They probably will. Now, if no charges are filed by a certain date, then the bail bond money is automatically returned to the bail bondsman, so whatever they put up with the court. But, and secondly, if charges are filed later on, if you stopped paying the bail bondsman, then getting bail again from them or from anybody else might be hard if you have broken your payment agreement with them. And look, I don't work for them. And by the way, if a bail bondsman recommends an attorney to you, you should probably not hire that attorney because there are laws preventing bail bondsmen and attorneys from working together and getting kickbacks there. But a lot of them don't really care. It's sort of the Wild West, especially here in California and in LA, with some of the bail bondsmen and frankly, with some of the criminal defense attorneys. And by the way, this does not apply if you are the one who paid the full bail amount in cash directly to the court. So if your bail was set at $50,000 and you actually took $50,000, maybe in the form of a cashier's check, to the courthouse and paid it directly, then you will get all that money back. I hope you found this video helpful. If you do have a domestic violence case in California, feel free to give me a call. You can find my number down below. You can also just book a consultation directly online right there. And if you do get hit with a domestic violence restraining order, make sure that you come back here. Click the link in the description box down below to get your free first class in my course. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.